Part 9, 10, 11. Rule miscellaneous. Section 116 to 158. The duration of existence of caveat filed under Code of Civil Procedure 1908 is 90 days from the day when it was lodged. A woman who, due to custom and manners of the country, ought not to be compelled to appear in public exempted from the personal appearance in the court. However, nothing shall be deemed to be exempted when such women from the arrest in the execution of civil process. Any case in which the arrest of the women is not prohibited by Code of Civil Procedure. Both A and B are correct. B is a correct statement of A. Which one of the following section of CPC provide exemption of certain women of the personal appearance in the court? Section 132. Who among the following is not entitled to be exemption for the personal appearance in the court? Collector. Code of Civil Procedure exempt ministers of the state and person from the personal appearance in the court. Exemption from personal appearance in the court is provided under Section 133 of CPC. Who of the following is exempted from personal appearance before the court? All of these: Minister of the Union, Minister of State, Judges of the High Court. Which section of the Civil Procedure Code grant exemption to the member of legislature from arrest and detention under civil process? Section 135A. Affidavit to be filed in a court can be authenticated by the judge, a magistrate, or notary. All order on the notice served or given by any person under the provision of Civil Procedure Code shall be in writing has been provided under Section 142. Which one of the following section of the Code of Civil Procedure 1908 embeds the principle of restitution? Section 144. What is the meaning of restitution? Section 144 of the CPC. Restoring to a party on the modification, variation, reversal of the decree. A caveat lodged under Section 148A of the CPC will remain in force from the date it was lodged for 90 days. After what period from the date of filing the caveat cease to be force? 90 days. Caveat shall not remain in force after the expiry of 90 days. Caveat to be lodged. A right to lodge a caveat has been provided under Section 148A of Code of Civil Procedure 1908. Caveat shall not remain in force after the expiry of 90 days. A caveat lodged under Section 148(1) shall not remain in force after the expiry of 90 days. Which section of the Code of Civil Procedure provide the right to lodge a caveat? Section 148A. The caveat under the Code of Civil Procedure 1908 may be lodged when any suit for pending or institution of the above to be instituted. A person claiming a right to appear before the court may lodge a caveat under which one of the following provision of the Code of Civil Procedure 148A. Under Section 148 of CPC, the court can enlarge the time not exceeding the total day of 30 days. Where a caveat has been lodged under Section 148A of CPC, what is the period of expiry of which such caveat shall not remain in force? 90 days. The period of operation of caveat under CPC is 90 days. Which provision of the Code of Civil Procedure deal with the right to lodge a caveat? Section 148A of Code of Civil Procedure. The caveat shall not remain in the force after the expiry of 90 days of its filing. Caveat shall not remain in the force for the expiry of 90 days from the date from which it was lodged. Caveat under the Code of Civil Procedure shall not remain in the force after the expiry of 90 days. Under Section 148A of Code of Civil Procedure, a caveat shall not remain in the force after the expiry of 90 days. Lodging the caveat under Section 148A of CPC entitles the caveator to receive notice of the application. Time for instituting a suit can be enlarged by invoking which of the following provision? 148 of CPC. The provision regarding inherent power of the court are mentioned in the Code of Civil Procedure in section 148 to 153. B. The inherent power may be used quote for end of justice to prevent the abuse and the process of law. Under section 151 of the CPC, the inherent power can be exercised by any court: Supreme Court, High Court, District Court. The inherent power of the court can be exercised under the CPC for the end of justice and prevent the abuse of the process of the court. Under the inherent power of the civil court, it can pass order to necessary for the ends of justice or to prevent the abuse the process of the court. The inherent power to confer under section 151 of Code of Civil Procedure may be exercised by the Supreme Court, High Court, District Court as well as Civil Court. Inherent power under section 151 of CPC are both and be discretionary in nature in addition to the power conferred under the order provision of the code. Under which section of the CPC inherent power of the court has been provided? Section 151. Inherent power of the court can be exercised by for the end of justice and prevent the abuse and the process of the court. For the grant of the court under section 151 of the CPC, also known as inherent power. The inherent power of the court to meet the end of justice has been saved under dash of the code, section 151. The defendant want to file the application under section 151. The correct and accidental slip in the judgment is should filed anytime. Clerk and arithmetical mistake. The judgment order etc. can be corrected under section 152 of CPC. The power of the court to correct clerical and arithmetical mistake in the judgment and decree may at any time by exercise of the court and its own motion may at any time on the exercise on the application by or any of the same party. Section 151 of the CPC empower the court to amend judgment decree order in respect of clerk and arithmetical mistake, accidental slip and omission only. Under section 152 of CPC, the order can be corrected by the court where there has been a clerical mistake, an arithmetical mistake, an error caused by an accident, slip or omission. General power to amend any error, defect or any process of the suit vested by the court by the virtue of Section 153 of CPC. Which one of the following section of the Code of Civil Procedure provide for the trial to open court where public may be accessed? Section 153b. An order passed under Section 151 of the CPC is revisable. Under the provision of the Code of Civil Procedure, the court has no inherent jurisdiction to restore a suit dismissed for non-payment of the court, to restore the election petition for the dismissal of default, to consolidate the suit between the different claim. In which one of the following case it was held that inherent power has not been conferred on the court? It is a power of the inherent of the court. It is a power inherited in the court. Manohar Lal versus Seth Hira Lal. When the proper court fee is not paid by the plaintiff, the court shall grant a time to the plaintiff to pay the deficit court fee. Where any period is fixed or granted by the court for doing any act prescribed by the Code of Civil Procedure, the court may enlarge the period by not exceeding 30 days in total. In which case it was held that the order passed under Section 151 for restoring execution can dismiss a court while rejecting decree holder prayer for adjournment to be not to be taken necessary step is neither applicable nor revisable. Govardhan Das versus Lakshmiram.